Thank you very much for the opportunity to present at this Stanford Law School event on scarcity regulation and the Abundance Society. My presentation today is going to focus on metal 3D printing, patent law, trade secrets, and additive manufacturing. I am a professor of intellectual property and innovation law at the Faculty of Business Law at QUT. I have various different interests, but I have been doing a lot of work over the past few years in relation to intellectual property and 3D printing, particularly as part of an Australian Research Council discovery project. I'm sorry that I can't be in Stanford today, but I am very happy to be participating remotely. Stanford reminds me very strongly of Australia with the very distinctive smell of eucalypt trees around the campus. So I can certainly envisage you all at the event. As is always in Australia, I'd like to acknowledge the Turrbal and Yugara as the First Nations owners of the lands where QUT now stands, and we pay respect to their elders, laws, customs, and creation spirits. By and by, I just kind of note as part of my kind of project on IP and 3D printing, amongst other things, I had a look at some Indigenous projects that were focused on using 3D printing and making in relation to education, which is kind of an interesting dimension to the topic. My talk today is really going to give a brief summary of the discussion that I have in the longer paper on metal 3D printing, patent law, trade secrets, and additive manufacturing. Really, the paper is a response in part to some of the classic works of the organisers. So Devin Desai in particular was very prescient in kind of writing about the prospect of patent infringement actions kind of breaking out in the field of 3D printing 8 or so years ago. And Mark Lemley, another convener of this event, wrote a very kind of influential paper about IP in a world without scarcity. And in many ways, my case study is designed to have a think about some of those frameworks and predictions in the very specific context of metal 3D printing. So along with Danusia Mendez and Mark Lemley, I was kind of involved in a project mapping some of the issues in relation to intellectual property and 3D printing across the United Kingdom and the European Union and the United States and Australia. My work on metal 3D printing in some ways is a continuation of that, looking at a particular subfield of 3D printing. As you can see in the paper itself, I kind of have a look at the patent landscapes in relation to 3D printing and the significant attention being paid by policymakers from WIPO to the European Commission and the European Patent Office and the UK IP Office and IP Australia. There's been a kind of particular interest, I guess, in disputes emerging in relation to patents, given the thickets of patents that are kind of appearing. And really, in terms of my case study, I'm very much focused upon the litigation by Desktop Metal against Markforged and some of its employees in relation to intellectual property and metal 3D printing. Also like to kind of interrogate some of the further violations claimed in relation to trade secrets and contract law. And I'd also kind of like to discuss some of the other issues that arose in relation to settlements and requirements in relation to non-disparagement. Just to wrap up, I just wanted to flag that there are a couple of emerging new metal 3D printing disputes involving the protagonists. I think a curious thing about my case study is that there's not necessarily a kind of a clear victor in the conflict between these two rival Boston metal 3D printing companies. The judge, the jury, and the arbitrator were all of the view that there was not necessarily a winner between the two companies in terms of the dispute. So I guess one of the kind of confounding things about the case is that really it's a case study in which the legal system allows the continued coexistence of the two rival companies. To begin with, I kind of paint a portrait of the parties and their historical development. The chart of a couple of geographers, I talk a little bit about the importance of Boston as a kind of a hub in relation to innovation and in relation to the development of fab labs and personal fabrication, and how it has kind of led to further development of specialist 3D printing companies working in the field of metal 3D printing. It's interesting to kind of have a look at how the companies portray themselves. You know, in its lawsuit against Markforged, Desktop Metal presents itself as a paragon of the metal 3D printing industry, saying that Desktop Metal, based in Burlington, Massachusetts, is accelerating the transformation of manufacturing with end-to-end metal 3D printing solutions. The company is addressing the unmet challenges of speed, cost, and quality to make metal 3D printing an essential tool for engineers and manufacturers around the world. The company kind of goes on and paints a portrait of its leader, Enric Philip, saying that he spent more than 25 years as an entrepreneur and a high technology investor, describes the other members of the creative team for the company. In its annual report, Desktop Metal highlights the importance that it places upon intellectual property, noting our ability to drive innovation in the additive manufacturing market depends in part upon our ability to protect our core technology and intellectual property. In addition to relying on patent law, they kind of noted that they also relied upon trademark, copyright and trade secret laws, as well as non-disclosure and invention assignment agreements. So really the company relies upon a combination of different forms of intellectual property, but it also kind of flagged that it may incur substantial costs enforcing and defending its intellectual property rights, and that the protection of enforcement of intellectual property rights is expensive and costly. So they were aware that it could provide limited protection. In contrast, their rival, Markforged, has stressed that, you know, it too is a kind of a leader in relation to additive manufacturing, and it has observed that the field is characterized by rapid technological change, intense and growing competition. It's kind of noted that it has been subject to business and intellectual property litigation in the past. That the additive manufacturing industry has been and may continue to be litigious, particularly with respect to intellectual property claims. So much like Desktop Metal, it relies heavily upon patents, patent applications, trademarks, copyright, as well as domain names, know-how, and trade secrets. There's also been kind of somewhat anxious about the international enforcement of intellectual property as well. Now, there's been a number of studies in relation to patent infringement in relation to 3D printing. Lemley and Sazdeck, Van Overal and Lays have kind of conducted studies of patent jurisprudence in relation to 3D printing. There's been some further work by Mimler and Desai and Maglokia. I guess we're now kind of starting to see some full-blown patent cases emerge, and I thought the kind of value of this study would be that it would kind of provide an early indication of how the patent system was really grappling with 3D printing. So in this particular dispute, Desktop Metal alleged that Markforged is seeking to compete directly with Desktop Metal by offering its Metal X 3D print system. It alleged that based on Markforged's recent disclosures, that its Metal X 3D print system uses a ceramic release layer that turns to powder during sintering. Markforged seeks to compete using Desktop Metal's patented technology protected by the patents in suit. Really, there was allegations by Desktop Metal that there was an infringement of 2 patents, one relating to fabricating an interface layer for removable support, and another one for fabricating multi-part assemblies. And Desktop Metal sought for a declaration, an injunction, an award of damages, as well as an order finding that the infringement was willful and it was an exceptional case. After initially declined to issue a media statement, Greg Mark of Markforged issued a statement about the litigation, saying, we now have the most advanced technology platform in 3D printing, and I'm incredibly proud of what our team of engineers have accomplished. And he stressed that Markforged categorically denies these allegations, and we will be formally responding. So Markforged had a range of defences. They kind of denied that there was any patent infringement, whether direct infringement or induced infringement or contributory infringement. They argued that the patents were invalid. They maintained that the claims should be barred by reason of estoppel. They also tried to argue that they had a license. They maintained that the patents were unenforceable. They argued that Desktop Metal should not be entitled to relief. They raised questions about unclean hands, and they denied that there had been any damage suffered by Desktop Metal. Case was brought before a 12-person federal jury in Boston on the 9th of July 2018. After 3 weeks on trial, the jury reached a verdict on the 27th of July 2018. Curiously, the jury found that the patents were valid, but they had not been infringed. So in relation to patent 118, they said that the claims had not been anticipated, they weren't obvious, they weren't indefinite, but they also found that there was no direct or indirect infringement of those patent claims. Likewise, in relation to the 839 patent, the jury said that the patent was valid, it hadn't been anticipated, wasn't obvious, wasn't indefinite, but they maintained that there was no direct or indirect infringement. They, moreover, said that there was no willful infringement and that there should be $0 damages awarded in this case. Greg Mark of Markforged commented on the outcome. We feel gratified that the jury found that we do not infringe and confirm that the Metal X is based on our own proprietary Markforged technology. Desktop Metal, for its part, was pleased that the jury agreed with the validity of the claims in both of Desktop Metal's patents asserted against Markforged. There was then a kind of a secondary battle over trade secrets and confidential information and some other related matters associated with unfair competition and contract law. As Mark Limley has noted, field of trade secrets is puzzling, defying easy categorization in relation to its disciplinary identity. Nonetheless, there's also been a kind of very dramatic expansion of the operation of trade secrets law. There's certainly been a few other cases that have appeared in relation to 3D printing and trade secrets. In a book on the additive manufacturing of metals, John Maliski has commented that trade secret law is evolving in an attempt to keep up with information privacy, cybersecurity, hacking, and a highly mobile global workplace. In this particular case, Desktop Metal had kind of complained that an intern had a familial relationship to a Markforged employee, and that they had taken away trade secrets from Desktop Metal. And they also, in addition to making allegations in relation to trade secrets, raised issues in relation to unfair and deceptive trade practices. Markforged, for its part, made a number of responses denying that there had been a breach or violation of the trade secrets of Desktop Metal. But they also raised counterclaims, and they kind of argued that there had been unscrupulous and deceptive conduct by their rivals, and that their trade secrets and confidential information had been violated, as well as there being a breach of contract law and questions in relation to unjust enrichment. In relation to trial, settlement and arbitration, really this matter was briefly aired with a trial. So Judge William Young was kind of presiding over the matter. Both parties kind of made very critical statements about one another, as you can see from my paper. Perhaps in part because of those reputational risks with the two metal 3D printing companies. The trial did not finish, and the parties decided to reach a settlement. And the settlement said that they had resolved all outstanding litigation between the two companies, and both Desktop Metal and Markforged acknowledged that neither company nor the individuals named in the litigation misappropriated any trade secret or confidential information belonging to the other. It's hard to know what the confidential terms of that settlement was. Then there was a re-eruption of the dispute between the two parties. Markforged alleged that there had been a breach of the settlement agreement. In particular, they kind of argued that there had been disparagement by Desktop Metal of Markforged. And in addition to kind of questions about the breach of the settlement, there was also allegations of breach of the Lanham Act and unfair and deceptive practices, particularly in relation to communications with resellers, customers, and potential customers. In return, Desktop Metal counterclaimed for a breach of the parties' settlement agreement in relation to confidentiality. An arbitration was kind of triggered by the confidential settlement. And in the end, the arbitrator apparently handed down a decision saying that neither party was liable pursuant to their respective claims, and that neither party therefore owed any damages to the other. So in some ways, quite a curious stalemate and draw between the two rival companies. I just want to wrap up by noting that the metal 3D printing companies have been involved in some further litigation with other parties. In 2021, Continuous Composites filed a patent infringement lawsuit against Markforged in the US District Court for the District of Delaware. And likewise, Desktop Metal has been involved in further intellectual property litigation elsewhere, getting a preliminary injunction in court in Germany that prevented Sprint Ray from selling its systems there. So obviously, the dispute that I focused on in terms of my case study is just a beginning of further conflict. Just to wrap up, I think the dispute raises really interesting questions around patent validity, patent infringement, patent remedies, as well as trade secrets, contract law, consumer law, and unfair competition. Perhaps there hasn't quite been the Napster style level of mass infringement that Desai anticipated. But nonetheless, there has certainly been very intense competition and rivalry and conflict in relation to metal 3D printing. I think kind of taking the longer view in relation to emerging disruptive technologies, there's often been rivalries that have spilled over into intellectual property disputes in relation to all sorts of fields of study. There's certainly been very intense patent races of late in relation to HIV/AIDS diagnostics and genetic testing for breast cancer and ovarian cancer and gene editing CRISPR technologies. So in some ways, there are similar patterns to previous patent races of one kind or another. Thinking about kind of the larger thesis of scarcity and abundance, the field of metal 3D printing still seems to be some way off a place of bounty and plenitude. There seems to be lots of technical limitations relating to materials and the technology involved to use metal 3D printing extensively. But nonetheless, there certainly does seem to be very intense conflicts at the moment. I do think the battles over metal 3D printing are critically important for all sorts of industry. So metal 3D printing has been deployed in relation to automobiles and in relation to aerospace and maritime industries and consumer goods and creative industries. In addition to intellectual property issues, there's going to also be larger questions about the regulation of metal 3D printing in those specific contexts. It's notable that the representatives of Desktop Metal and Markforged remain very upbeat and optimistic about the future of metal 3D printing. But sometimes there has been a bit of a hype cycle in relation to 3D printing. So we'll have to see how it matures as a technology. But certainly I would anticipate that there will be further competition and rivalry between pioneers and trailblazers in relation to metal 3D printing. But there's also a kind of a larger geopolitical struggle going on in terms of races for innovation at the moment between some of the manufacturing superpowers. So hopefully my case study has been kind of helpful for providing some sort of context for some of these larger discussions that we're having about scarcity, regulation, and abundance. Albeit my case study is a somewhat confounding and puzzling one, in the sense that the law really, in the end, has allowed the two rival metal 3D printing companies to kind of continue to operate, and has not really privileged one company above the other. So I think it's a kind of an interesting position of allowing the coexistence of rivals in relation to metal 3D printing in terms of the outcome of the dispute. But I guess, there are larger questions about to what extent is the matter representative of metal 3D printing and the larger field of 3D printing. So we'll have to have a look at some of the patterns of litigation as they play out in the future. Thank you very much for your time and attention. I wish you all the best with your event.